Hello friends, we move to session number 6, which is the third session relating to military law terms and phrases. In this session on military law lexicon, we are moving as earlier in an alphabetical order, and the first term is overstay of leave. As the plain meaning of the term indicates, it is absence from duty by a military person for a period after expiry of his leave. So, in a normal case, soldier should join back his unit place of duty when the leave is over, but if he does not, then it's a case of overstay leave. Patrol is a detachment, usually of about a section strength or a platoon. It is sent out by a larger unit for the purpose of securing information or denying information or carrying out some special mission. Penal deduction is a deduction made as a penalty for an offense of which an accused has been convicted, and it constitutes part or whole of his punishment, meaning thereby that penal deduction would usually be part of the punishment. In some cases, it can be the only punishment meted out to the defaulter. Plea to jurisdiction is one of the pleas taken at a court-martial by the accused. It demonstrates that the court has no jurisdiction to try him on the charge which is framed against him, and the relevant provision in this regard is Army Rule 51. Pillage is a term used when a property or money is taken by the soldiers, exacted by the soldiers by way of violent means. Plea in bar, another plea used during court-martial. This shows the ground that the accused has been previously convicted or acquitted, or he has already been punished, or perhaps dealt with summarily, or even the charge was dismissed or condoned, pardoned by the competent authority, and in sum and substance, it conveys that the accused already stands dealt with and he should not be brought to trial again. Relevant provisions, Army Rule 53, Clause 1. The next plea taken at a court-martial is plea of no case. This is advanced at the close of the case for the prosecution, and it is based on the argument that the evidence given by the prosecution in respect of one or more charges at the trial has not established a prima facie case against the accused. Post denotes a soldier's beat while on a sentry duty. Where a soldier has been asked to stay put in, it may be a bunker, it may be a fixed place, or between certain end point and start point. It could as well refer to a general area like Kargil. Now, pre-confirmation is the process entirely during the legal proceedings. It is undertaken after the finding or sentence has been announced by the court martial in respect of an accused, and this extends to the period when the proceedings are confirmed. Prejudice denotes an unreasonable dislike or preference for a person. It can be in relation to a group or custom, etc. also, and the applicable provision in this regard is Section 191, Clause 2 of the Army Act. Presiding officer is the senior most member at a court-martial, Army Act Section 123, and promise relates to a declaration made to another person with respect to the future, and it is there in Army Act 17, Clause 2. Rank is the relative position in the army. It is in relative precedence by way of grade or status. So, like it was discussed earlier, that say in the officer cadre, lieutenant, captain, major are various ranks at the start, and if the lieutenant is the junior most, then obviously captain is senior with regard to all officers of the rank of lieutenant and so on. Redress means to correct something that is apparently unfair or wrong, and therefore a soldier or a military man of whatever rank, if feels aggrieved, then he seeks redress, which means that please correct that grievance which the person has. Reprimand is one of the punishments provided in the Army Act under Section 71. It is applicable in the case of officers. It may take the form of reprimand or severe reprimand, which are relatively superior or more senior as is indicated. Reproof is given in relation to a minor offense or lapse. It is an administrative action. It is not a disciplinary action, and reproof may be administered, may be dished out verbally or in writing. The applicable provision is DSR RA paragraph 327. Revision is a process where a re-examination is of the proceedings is carried out with a view to any correction that may be needed, and additional information may be taken during the process of revision when it is so directed in the revision order which is issued by the competent authority under the Act. Next term is running amok. This term is used when a soldier who's armed has broken loose and at large he is threatening or purporting to kill anyone in particular or all or anyone in general, and then it is the duty of the soldiers who are ordered to apprehend him, to control him, to do that. And in case if a soldier who is ordered to control and apprehend a person who has run amok does not do so, then the gravity is same like cowardice in the face of the enemy. Safeguard. This is used to denote a party of soldiers which are detached and deployed for protection of some person or persons of a particular village, house, etc. So if there is an important person who's to be protected, then a safeguard may be deployed over him or in relation to a building, a village, etc. A sentry is a soldier who's posted for protecting some place, property, or person. And set aside is used to convey, annulling, quash, or rendering void the proceedings. So proceedings may be set aside or an order may be set aside. Shamefully is the term used with regard to offences in face of enemy, and this term refers to a negative and disgraceful dereliction of duty. So it's not merely dereliction of duty, but that is done in a manner which is unsoldierly or disgraceful, and that's why a serious view is taken of shameful acts. A show cause notice is actually a notice, or it's an opportunity provided to make something clear or one's version apparent by support of suitable evidence, testimony, or even reasoning to indicate one's version with regard to that matter. Sine die is the term used when the proceedings are put off without indicating any date, a distinct date or a day for further meeting, and this is usually put to use in relation to a court-martial or a court of inquiry. The speaking order, as the term indicates, it is an order which contains matter which is self-explanatory or illustrative. Therefore, it is an order which speaks for itself and indicates the reason that is given with regard to the order. A special plea to jurisdiction is one of the pleas available to an accused during passage of a court-martial, where he makes an objection, raising a plea that the court is improperly constituted. Or it may also relate to when an accused is not subject to the Army Act, or the third contingency can be that he is subject to the Army Act but is not subject to be tried by that description of court-martial. Now, a typical example would be that an officer being brought to trial by a district court-martial. Now, district court-martial's jurisdiction does not extend to an officer. So then a special plea to jurisdiction would be raised if such a contingency takes place. Stoppages are the orders in relation to amounts meant only to compensate for loss or damage caused by an offender. Now, say an offender has lost his weapon, or he has caused damage to certain property. Maybe even the driver and the motorcycle issued to him has been damaged. So the stoppages, which would be from his pay and allowances, can be ordered by way of disciplinary action to make good the loss that he has caused. Summary award is in relation to officers below the rank of Lieutenant Colonel, JCOs, and warrant officers. They may be summarily dealt with, which is an abridged form of a trial. And the relevant sections in this regard are 83 and 84 of the Army Act. Summary punishment is the range of punishments that can be inflicted by a commanding officer without recourse to a court-martial, and these are provided for under sections 80, 81, and 85 of the Army Act. Next term, summary of evidence. It is record of the unsworn statement in relation to the charges against an accused. It is taken on the orders of his CO, and it includes statement of the accused, if any, made by him voluntarily, and of the witnesses that he wants to produce. So it is to be remembered that it is an unsworn statement. A witness is not sworn, or his evidence is not taken on oath. Only the commanding officer can order recording a summary of evidence, and accused is always present during the entire recording. He is cautioned that if he wants to make a statement, he can do so, and he can also produce his own witnesses for the defense of the charge. Summing up is the address given by a judge advocate at the conclusion of the evidence. It sums up the evidence and it advises the court on the legal position with regard to the charges framed in the charge sheet against that accused. And this may be seen in Army Rule 60, 68, and 105, Clause 5. Suspension of service. An officer may be suspended from duty, which is independent of arrest. It means it can be coupled with arrest and may be independent by his commanding officer or any officer superior to commanding officer. It can be done when he submits his own case for investigation, and also in other cases when his character and reputation, conduct as an officer or as a gentleman is impugned. Now, if he has done something, say, disgraceful, which doesn't bring him in good light as an officer and as a gentleman, then he may be suspended from service. Termination. It is interchangeable with removal, and it means separation from service. So an officer, his services may be terminated. It means he gets out of the service. Threatening language is used when a person subject to Army Act uses language which can reasonably convey an impression that criminal force may be used. So where a threat is given that, well, I will use force against you, it may be said, it would be said that I have used threatening language against that person. Treacherously is another term used in relation to an enemy, and it implies an intention to assist the enemy instead of working for the cause of own forces. If the word treacherously is used, it would convey that the person concerned wanted to and tried to assist the enemy. Unbecoming conduct relates to a conduct which is not befitting the position of officer, JSU, or warrant officer, as the case may be. So, unbecoming conduct is only used for persons above warrant officer's rank, warrant officer, JSU, and officer. And this unbecoming conduct may relate to a military or social character. So it can be seen from two angles, and the conduct may then be characterized as unbecoming. Voluntarily, obviously it means by oneself or of his own free will. Warrant is the document, the form is laid down under the Army Act and the rules, which empowers the process of convening and confirming GCM and DCM. That is General Court Martial and District Court Martial. And willfully means something which is done purposely, intentionally, or deliberately. So it is not something which is done accidentally or at the spur of the moment. These were the terms. Today was the third and the last session relating to military terms, law lexicon. Their clear understanding with the meaning of the terms would hugely help you in proceeding further with the passage of this military law series to understand the various facets of military law. Thank you.